All right. Hello, everyone. This is Curt Barone,
And Brad Pinsky.
and we are here for another edition of Fire Law Roundup for April 29th of 2024. One thing before we start, Brad, today's a birthday to one of our regular listeners, and let me just get this. All right. Hello, everyone. This
Boy.
is Curt Barone.
Yeah, I
This
feel like I
thing,
just heard
this
that.
this thing never fails. And
The benefit of live shows.
oh man. Okay. Hopefully that doesn't screw us up too bad. So, yeah, it's the birthday of Detective Lieutenant John W. Barone, who
Of
religiously listens and also criticizes our criticism of police. So
course he does. Of
we
course he
get
does.
that. I think I still say it. I told him this a couple of weeks ago that he's really a firefighter at heart. When he was a younger man, he was a firefighter, and then he somehow,
Went to the dark side.
and but he is one of our regular listeners. I know that because he criticizes what we say. So
Great.
he's
Well,
probably
hand him a
listening
cigar
now.
and a drink, and he'll be good.
Yeah. All right. So
Um,
let's go. It's
Kansas
let's
City.
see. Yeah. Yep.
Let's start with Kansas City. So
Yeah.
this is the case that will never go away, it seems. Right? You and I must have covered this so many times. I
Five
actually
times,
was in,
6 times. Yeah.
Yeah, I mean, I actually was in the newspaper about this, talking about the female's complaint, right? It was this one where she kept saying he was a bad driver and
Yeah.
nothing happened. In any event, what we have here is which is going to seem shocking to people. Honestly, we have the disciplinary side of this whole criminal issue, right? So we have, look, if you don't know what we're talking about, this Kansas City had this individual driving an engine, and he was driving it recklessly, criminally recklessly, the court found. He was convicted of involuntary manslaughter for killing, I think, 3 people. He pled guilty, and he was had a verdict of $32 million to the victims of the crash. This is the least exciting part. This is the disciplinary side. They never terminate him. Kansas City never terminates him. They suspend him like a lot of us do. They put him on, a non-punitive administrative leave while this is happening and the investigation's happening. That's generally routine, although maybe it wasn't in the CBA. Nonetheless, this goes before the arbitrator. An arbitrator, there's a whole challenge over his discipline. The arbitrator says the court, which we'll talk about, really goes outside the bounds of what the arbitrator was supposed to do and reduces this to a 3-day suspension without pay, which alone is insane, right? You kill 3 people, but you're good. 1 day of suspension for each victim you killed is what is the best anyone can come up with how the arbitrator got to this. In any event, the arbitrator, there's a challenge to it then, and the arbitrator or the court can't justify what the arbitrator did. There's no explanation of any how the arbitrator reaches the conclusion, other than people, they're guessing, well, maybe they gave them 1 day of suspension for each dead person. But it really is very shoddy. And what happened, the ruling here is that the arbitrator went beyond the scope of what the arbitrator is allowed to do. I can't believe the person wasn't just terminated point blank.
Yeah, and I'm not sure what that is, but typically, particularly in a metro-sized city where you have strong unions, strong collective bargaining, and some protection through various statutes, that the member was just suspended pending the outcome of the criminal case, which is really what you should do. You shouldn't jump to conclusions. Not that this is a pretty good case where the conclusion you're going to jump to is right, but you still shouldn't jump to conclusions. So we suspend them, get them out of the workplace. They had apparently some sort of a city ordinance, or I know in Providence, a lot of the discipline was governed by the city charter. So I think many places it's governed by either state law, city charter, however you're going to treat your employees. In fact, in Rhode Island, if you're facing a felony, you can be suspended without pay. That's by state law. But regardless, pursuant to that, he was suspended without pay. And it was about 2 years later, I think it was 2023, when he finally pled guilty. But there was a question about, I think, how long can you suspend someone without pay without giving them a hearing? And so that was the real issue that the arbitrator should have been dealing with. But the arbitrator went beyond that and somehow reached apparently the conclusion that he had been terminated, and his termination a proper outcome for this type of an offense. But I got a question. There's a euphemism in Texas. What is it? Indefinitely suspended.
Oh, yeah.
It's a euphemism for being terminated. Okay. But at what point is it 2 years? Is it 3? Is it 4 years of suspended without pay? At which point you're entitled to a hearing or some sort of process. So I think that was probably the issue, but the arbitrator appears to have gone beyond that, at least according to the complaint. And it's funny too. I don't know what you do in New York. Here it would be you'd file a complaint. They filed a motion.
Yeah.
How do you file a motion without a lawsuit? A motion is part of a lawsuit,
Right.
but they filed a motion to vacate. So whatever, procedural in Missouri. But at any rate, the narrow issue should have been that temporary suspension as opposed to the outcome. And the arbitrator appears to have made a final determination that all you can discipline this person for is 3 days without pay.
And, look, the whole issue, we won't get too far off this line, but the whole issue of what I call non-punitive administrative leave, where you can call it whatever you want, but it's days off without pay.
Right.
In New York, if you're civil service, not governed by a CBA, there's a law on it, right? And probably many states there's a law on it. But, there's the employer and the employee side, which I agree with both sides. The employer side is, wait a minute, this person may have done something wrong and we don't want them at work, right? So that's one issue, fine. And if you send them home without pay, who cares? It's a paid vacation.
Mm-hmm.
But that's not what employers are doing, right? They're sending you home without pay. And if you're found not guilty, then we'll pay you back pay, etc. But on the other hand, that's great for 30 days. But what do you do a year or 2 years? You just can't do that. At some point, you've got to be deemed unemployed. You file for unemployment, but you're not terminated. It puts everybody in a horrible situation. My suggestion is I hope the CBA deals with this and it's a pre-negotiated, right? To me, I would say the best CBA I've seen is, it kind of models New York law, frankly, but I've seen it in other states. You get 30 days, right, initially without pay, but after 30 days, if our investigation is not complete, you have to start paying them, because otherwise, and I've seen, God, this is forever ago, a court ruled that we're not going to penalize the employee for the employer's lack of diligence, because it turns it into a suspension. So I think 30 days without pay, you got 30 days to figure it out. And then you got to pay, you got to charge, you got to investigate, whatever it is. But 2 years is insane. So I get the arbitrator, but
I agree with what you said up to a point. I think not that you have a right to come back, but after 30 days, you have a right to a hearing.
Right.
And that hearing is not to determine your ultimate guilt or not, but the hearing is so that you have the opportunity to say, it wasn't me, I know this looks bad, it wasn't me, or it didn't happen the way they're alleging, or something of that nature. But basically your due process right. Okay, that's, the right to be told what you're accused of having done wrong, and the right to explain or rebut. So essentially you have that hearing in the middle there. But many of the statutes I've seen don't say that. They said that during the course of the criminal case, and there's also a strategic, I just wrote an article for Firehouse, I think it's either in this one or next month, on this very issue of when can you, or when is it advisable to delay an investigation because someone's facing criminal charges. And this is a classic case because, as you start to, first of all, if the person's got a criminal attorney, they're not going to want to talk to you.
Correct. Okay. Which is normally how I deal with it, is everyone agrees they'll just stay away, because what the defense attorney doesn't want to see is, oh, even your own department thinks you're guilty and they turned on you, they suspended you, they whatever. So right. I agree with that.
But let's kind of take it in a slightly different venue, a slightly different set of facts here. When someone is on duty, and there was a case out of Seattle where a firefighter was accused of having sex with a 15-year-old on duty in the parking lot at the firehouse, and so now you've got this criminal case playing out. Well, in order for us to make our case that this person should be suspended beyond 30 days, guess what?
You got to investigate.
We've got to investigate. Where does the investigate? Who do we have to investigate?
Right.
Who do we have
and
to
yet,
interview?
don't we have Garrity / Weingarten /
Well,
whatever
you do,
issues coming to
but here's my point. At some point, we have to interview the victim. And guess what? The police are not going to let us interview the victim.
No way.
So
No way.
you see what I'm saying? So I think that there's a lot more when there's criminal conduct, on-duty criminal conduct involved. The 30-day, yes, you should have some sort of almost like a probable cause type of hearing. Because, again, I agree with you. You shouldn't be suspended for 2 years and not have any sort of hearing. But the employee should also, through counsel, have the opportunity to say, we waive that hearing.
Right. And look, just so the viewers understand what we're saying is an employer doesn't have to wait for a guilty plea like they had here. That should have been easy. Doesn't have to wait for the outcome of criminal or civil or other investigations. They can do their own investigation. I have a case where somebody was shoplifting in a jacket of the employer, right? The bright fluorescent jacket. They're on video shoplifting, sticking stuff in. Yes, there's a criminal investigation going on. I didn't need it. We had the video. We could see what the person's doing. So we terminated the individual because they're shoplifting. Normally, however, I would say don't interfere with a police investigation, right? Or you're not going to be allowed to interfere. You can't interview a 15-year-old witness. But if you can prove it, like with a video or something, or you have a dash cam or something, you're allowed to do that for your hearing, but you're going to have Fourth Amendment or Fifth Amendment issues as well, right? With interviewing people, they're not going to
absolutely. Oh, absolutely. We've got Garrity written all over it, but that's only part of it. We can still usually we'll be able to prove the case without the person testifying,
right, like a video,
right? But the problem is, in some criminal cases, we're not going to be able to have access to the victim. And in fact, if we try to, I actually put this in the article. I mean, if you tried to interview a minor who had been sexually assaulted, the prosecutor's they're gonna charge you with witness tampering and obstruction of justice. Then you can't go near that witness.
Right.
So then that means we can't do our full investigation. That means we got to put our feet back and wait till the criminal case is over.
And if it's off-duty conduct versus on-duty conduct, we have Garrity issue, right? I mean,
right. That's it's usually it's going to be an on-duty issue with Garrity. So yeah.
But I would say this, as you and I will say a lot coming up: policy, policy, policy. A lot of these things better be dealt with in policy, whether it reflects state law, whether it reflects your CBA, policy, policy, policy.
Yeah, and I related to that, we can talk about what I call the three-legged stool of liability. Okay, and you've got to have policy. It starts with policy, then it's training on the policy, and then it's effective supervision to make sure that we're following the policy and so on. So it's really, you've got to have all three legs, or else the stool's going to tip over on you. Okay, policy, training, and effective supervision.
Okay, so now let's go to, so there were 3 cases, this was one of them, which have a common theme here. Even though it wasn't your intent, I found a common theme here of shoddy lawyering, shoddy investigation, shoddy something shoddy. Why this outcome? So in the first one, we had a shoddy arbitrator, went far beyond where they should have. Frankly, you also had a shoddy employer because they had a guilty plea. They could have dealt with this pretty easily had they charged him properly. But getting away from Kansas City, let's go to New Hampshire. And here we have and this is your three-legged stool in a sense that has now collapsed. We have a firefighter who is not gay, but has been harassed repeatedly for, I don't know, that they're making homosexual-based jokes about the individual. He claims he reported it, right? This is just a complaint. These are claims, so there's no finding of fact here. But he is now sued. It's now been moved up to federal court, and he claims that this started back in 2011. And I'm we're going to get down to your point of this, right, for everybody. But so I want to use the dates as much as I can, that this started in 2011 with him being the recipient of comments about him being gay, despite the fact that he's not, right? And it doesn't matter whether he is or isn't, whether it's truthful or not. You can't pick on somebody for being gay, thinking they're gay, making fun of anyone else who is gay. You can't do that. Even back in 2011, you couldn't do that. And as you and I have said this, as many employees do, they start writing the comments down. He started, and it's going to be incredibly influential because he's writing quote unquote real-time logs of comments that are made. Who, I assume it's who made it, where he was, what was said, etc. He then complains to HR, which is in 16, right? Allegedly takes these comments for 5 years, all right, and then reports them. But here's your leg of the chair here, right? That no investigation was done at that time, and the harassment continues. At this point, if this is true, there's a lot of problems. The problem here, however, may be one of statute of limitations, because this is not within 1 year or 300 days or 3 years, whatever you want to do. We're back in 16. So they may be relieved of some liability, although the history of this is going to be important. In any event, in 2020 now, he again files a complaint, which probably is the only surviving part of this that we'll see. And now finally it led to an independent investigation. So of course, you say it all the time, and we see it all the time. Lawsuits on discrimination always have a counterpart, which is retaliation. And here you go. He claims that when he filed a complaint, he's now being ostracized, scrutinized by his officers, transferred against his wishes. He's being retaliated against. However, the investigation allegedly found no evidence of any hostile environment and no evidence of retaliation, which I question who did the investigation. Not because I'm saying it's wrong or right, but who did it, right? But did find that inappropriate behavior, which runs counter to the department's policy on non-discrimination, sexual harassment, did occur. Okay, they've substantiated some of the behavior. I don't know which part of it. He couldn't tolerate anymore. The individual resigns in 23. I don't know why. After taking this since 2011, why he resigned in 23, but I'm not in his shoes. I can't say. And now he's alleging, a constructive termination as well as hostile environment, etc. This is a great example of how not to handle anything. Right? I mean, and you make the comments.
Yeah. And I just finished a class. The class was advanced social psychology. And, we had to read a lot of research papers and, the main textbook. But we got about 3/4 of the way through the class, we discussed the phenomena that I had never heard the term before, but it's called mobbing. Mobbing. I had never heard of it either. But apparently it's when people, it could be on a baseball team, or it could be, some sort of a group activity, but it also happens very often in the workplace, where people, as a mob, start bullying somebody. Okay. And, it's a documented phenomena. It happens. I've seen it happen when I go back through my own experiences. I've seen it happen to certain firefighters. And again, I don't know this person. I don't know anything that's going on in this situation, but very often a person has a difficult personality, and they are sort of misperceiving some of the things that are happening as being more threatening than they actually are. And people are, it starts out that way. But what happens is once they complain, now the hyper scrutiny, now they've stepped over this magic or invisible line of what you should and what you shouldn't do about our group norms. And it's almost like it's like a textbook scenario. And the difficult part here is understanding it from not from the employee's perspective. We get it from the employee's perspective, but from the people who are now accused of bullying. They would say, well, we weren't bullying him. He was acting like a jerk, and we were treating him like we treat all jerks, you know? And I'm speculating here. I don't know for sure. But what we've got to understand is that even a difficult person, you can't bully, you can't pick on somebody, even though they may be a difficult person. That's, you know, it's where leadership has to kick in. That this person's company officer, and then right on through the chain of command, we've got to make sure that once we recognize that we've got a problem, even though the person may be a pain, that we cannot allow that kind of continued harassment to go on. And I know from having to manage one of these that ended up in federal court after I had retired. But the firefighters feel like they're justified in treating the person like this, and maybe objectively, if it was a group of firefighters, you'd say, yeah, you know, I can see it. But it's almost like the firefighters don't realize that you don't want to help this person in the least. You don't want to help. You're basically writing a multi-million-dollar check to this person by your continued harassment of them. Right. You're making it easy for them to get a big payday. Why would you do that? And they don't see it. They don't see that part of it. They see the day-to-day stuff, and they don't see
yet
that
it would be better if they said nothing and just kind of silenced the person out, because then they can't, you said this, as opposed to you were quiet, you were silent.
And then that feeds into the ostracism also. You know, so it's not a good scenario. Okay. And it's one, again, I think it's connected to what I really want to, you know, work on the research on, is to really kind of get a deeper understanding of this with an eye toward how do we prevent it, or how do we better handle these when they come up? Because these are the things that are leading to, you know, I'm sure if I went up to Concord and talked to the people that were involved in this,
very different story.
Totally different story from what is alleged here. And that there'd be a lot of morale problems and upset people that are upset about this as well. And it doesn't do us any good to have these kinds of things going on in the department. So if we can get a better understanding of how to better handle them, the whole organization is going to be better off.
And look, we say this a million times. We don't know. We're not there. Right. We don't take a side. We're just relaying a complaint. But, you know, there's the few good men code red side of this too, where the leadership turns the blind eye and says, we do not want you to touch that person. Yet they recognize the importance in some sense of bullying, hazing, harassment to get somebody to fall in line with the group. I'm not justifying bullying, hazing, harassment, but there's a scientific...
And it's hard to stop it too. Let me tell you, it's hard to stop it.
But the leadership, if they turn the blind eye, you know, wink, wink, please don't, no code red for this, then the membership picks up, okay, we're going to handle this. We're going to bring this person in or force them to quit, one or the other, fall in line or fall out. And I think, look, I still bring it back to the leadership. The leadership has got to stop this. This will not be tolerated. And investigate.
You know, we're pretty good. You know, we're pretty good at putting out house fires. We're pretty good at EMS. We're pretty good, but we are not very good. And nobody, I'm not saying, I don't know anybody, myself included, that's good at handling these difficult HR types of issues. It's a learning process. And I think that's really where I want to focus the research, because we've got to get better at this. And again, my lesson, my advice to the people who are in the position of having to deal with a difficult employee is your harassment, your continued harassment of this person is like writing them a blank check. Why? You don't like the person. You don't want to work with the person. Why would you give them a blank check?
And they're going to call you as a witness.
Is doing.
Right. I think we just don't get it. But I will tell you, you know, in this, you're taking organizational behavior and group dynamics classes. That was part of my background with my master's. And one of the things about the fire service that always impresses me is we're not like a normal workplace. We are not. Normal workplaces do not depend on each other, where the lowest, most irresponsible person collapses the truss, so to speak, right? It's everything fails. You take one firefighter out of the truss and our whole operation fails. That's not like a normal workplace. So for us, it's like the military. It's incredibly important that we work as a team. It's not even like the police because they ride 1 or 2 people in a car. We're 21 people on the fire ground, maybe 4 on an engine or whatever that have to work as a team. And the bullying, the hazing, the harassment, the whatever it is to get you in line or get you out has a place. Just not that way, right? And not through harassment, but we see the value in it, which is the problem with the fire service. And we've talked about this. There is a scientific value to harassment, hazing, and bullying. I'm not saying it's right, but there's a reason to build the trust, to get people in line, to act as a team. There's just got to be a better way.
Right. And I think getting it to the point where our company officers and chiefs as well, but can recognize we've got a problem now with Joe. Okay. And so now we've got to find a way to back off, even though tomorrow with Fred, it's going to be fine. But today with Joe, we're just not going to be able to do this, you know, and trying to recognize where that point is, because otherwise Joe's going to get a $6 million check. And if you don't like Joe, why would you help him get a $6 million check? You're saying you don't like him. You don't like working with him. Why would you help him get a $6 million check?
Yeah. And I think it's because we see people as weak. We don't think they're going to sue. We don't realize we're so bloodthirsty. We're so immersed in our own power at making this person feel powerless, i.e. being a bully, right? We don't recognize that person's going to be empowered, come after us, and we're going to be the one who's right at that person's will. We're going to be the not bullied, but the victim of this.
And there's some group dynamics. There's some psychology of group dynamics where it gets pretty complicated. But the same thing that happens in riots, where people sort of lose their moral compass. Yes. And kind of follow along with what the group is doing. And that, I think that's playing a role in the mobbing problem.
Oh, which we call groupthink, right? You start to fall into that groupthink mentality, but it's not real. Anyway, okay. So we could analyze the fire service perfectly
out of that one.
Way off. All right, let's go to New Jersey just for a second, because this is a interesting decision, but I didn't think it was shocking. The question is whether lieutenants who had been in the same bargaining unit as the regular, rank and file, whether they should have been out of the bargaining unit or not. And the court has some very interesting things to say if you're interested in this particular issue of who should or shouldn't be in the bargaining unit. But the test they come up with really was to look at the duties and the authority of the superiors, the lieutenants, versus the rank and file. Here they said, looking at that, they're very similar, right? Maybe there's some evidence, which wasn't here, that lieutenants could recommend binding or almost binding results, that they had significantly influential recommendation authority. That's my words. They call it recommend authority. But and here the court says, listen, the rank and file and the lieutenants are almost identical. There's nothing, which is very common, by the way. I just haven't seen a lot of cases where lieutenants are not in the union or not in the bargaining unit for this reason. So I was a little shocked, but it's a good test. It helps people if you're struggling with the issue. This court gives you the good test. Are the rank and file lieutenants pretty close, or can the lieutenants or whoever really recommend effective discipline or whatever, that they really are superior?
Yeah. And I get the sense from this community, I think it's called Carteret, I believe, Carteret, Borough of Carteret. And they're in my database on labor stuff. And for a small municipality, they're noticeable. So I when that happens, I get the sense that maybe there's some anti-union perspective on the municipality side, whether it's elected officials or local officials, or I don't know, but this is not the only case involving this department that's in my database. And so I hope they can work their way through those battles.
And the way they could have or should have, I'm not saying they didn't, but I'm guessing they didn't, It starts again. What's that word? Oh yeah, policy. But here, job description, right? What was the job description? Just like when we're in a minute, we're going to get to the executive pay, even though it's a pay issue we'll talk about. But what is the job description? Job descriptions, like policies, like everything else, matter. And if your job description doesn't create that they actually have enforcement and superiority as to the rank and file, they're not going to be rank and file. Just like when we jump to deputy chiefs, what's their main job? Responding to calls or administration, right? All of these words matter.
Well, in this case, when they first formed the union back in '65, the lieutenants were in the same bargaining unit as the firefighters, and now all of a sudden, like, was it 2019 or whatever?
Yeah.
Now the city wants to separate them out, and to me that speaks of some sort of a strategy that they want to divide them. And I don't know what their staffing levels is, but if you've got one officer and 5 firefighters, like New York, arguably, maybe the officer should be in a separate, but if you've got one firefighter and one officer on a truck,
yeah,
you're trying to divide and conquer. Even 1 and 2, you're trying to divide and conquer. And so now instead of having one strong local, you've got 2 weak locals.
Right.
And so that's, I don't know. I think there's a strategy going on that hopefully, I believe the court kind of saw through.
Got dogs barking everywhere, and I don't know if you guys can hear them.
Real life, right? Real life.
Yeah, well, yeah, dog comes to the office every day. He likes it. He warns us of sketchy people.
More real life. Hold on a second. Yeah. But go.
All right, let's go from New Jersey to Massachusetts. This is another great example of shoddy record keeping, investigation, lawyering, all three. I don't know, but in Massachusetts, we had, and this is very damning. These words about the department, Brockton Fire Department, are very damning. And I just want to be clear, they're not our words, right? We didn't write this, but we're going to repeat it. So the Massachusetts Civil Service Commission grants an appeal she applied for a position with the fire department.
Brad, I'm gonna leave you. Okay. I'm gonna need to go, but I'll be back in touch.
Okay, so I'm guessing that he just had a call. Not a problem. But so I'm going to continue here. So Curt, as everyone knows, is a deputy chief and fire department. We're wildland season. They have a lot of wildland fires. So we're going to I'll continue this. So we have the Massachusetts Civil Service Commission grants the appeal of an applicant. This is for the Brockton Fire Department. And the commission concludes that the city did not have proper grounds to bypass this female applicant. She ranked 4th on the list, on the hiring list, but they didn't hire her. And so in 23, when the department seeks to hire 16 new firefighters, that applicant was bypassed. Now, the city came out with reasons and said, oh, you're missing information on the application, which seemed to be not legitimate reasons. And so the commissioner then rules, right? It's not a court, but it's still this, commission, states that the city failed to prove that it conducted a fair and impartial and sufficiently thorough review. Now, that's why I said this was bad, whatever, administrative process. And the commission's beating them up that they didn't do a good review. And they said the city failed to submit evidence like a simple background investigation report that outlined why the applicant should be bypassed. And they go on. The city failed to call a background investigator as a witness. So they're saying, okay, what did the investigation find about this person? They didn't even put that in. So maybe that's bad lawyering, or maybe it's lawyering a lawyer had no choice because there was no background investigation that would have helped them. Who knows? But here's the damning part. Let me read what the commission says. And this is going to haunt this department. These are not my words or Curt's words. The city's dearth of evidence and lack of thoroughness is particularly troubling, given the damning and potentially career-damaging conclusions of the department, whose makeup is 86% white and 99% male, that a female candidate of color was untruthful and deceptive, of finding that an applicant for a public safety position has violated the duty of truthfulness, requires that any such charges must be carefully scrutinized such that the applicant is not unreasonably disparaged for honest mistakes or good faith mutual misunderstandings. And the commission goes on and on and on to criticize the department on not being able to say why this individual was bypassed. And again, people, and Curt and I have said this so many times, your makeup of your department, how many women, how many men, how many minorities, right? How many Caucasian, all of that is going to come back to haunt you. Everyone needs a policy and an effective program to diversify the department to at least equal the diversity in the community, right? If your community is 30% African-American, then your department needs to reflect that, or you may face a court mandated order to force that. But here, it doesn't look good for the department. Now, I'm not saying the commission will be the end of this. Maybe they'll appeal it, but it doesn't look good. And the statistics don't help. But a bad investigation, three-legged chair, as we're talking about with Curt, a bad investigation is going to come back and haunt them. They made claims. They didn't back them up. They didn't present evidence of those, of the proof of why they didn't hire the person. What did the investigation find? And there you go. And this is embarrassing. And let me say one other thing. This is in the public. Obviously, we're covering it, but this is in the public. Your community, and I don't know the makeup of the community, whether it's, minority or obviously I'm sure it's 50% women, but whether it's African-American or not, I don't know. But your community is going to see this. And that is not how you build trust with the fire department, right? People don't want to be fearful or believe that their fire department, that their police department doesn't reflect the community. So this is not good on anybody's, but we can't do anything about what happened to them, what they did. But please, if you're not going to hire somebody, you better have darn good reason. You better be able to prove it. You better investigate. You better be fair. Okay, so lastly, and I can almost end with this, this isn't surprising to me or anyone in New York State because we've had higher numbers, but the Department of Labor, not surprising, we've known this is coming, has increased what we call the white collar salary test. So everybody knows, please stop just saying, oh, you're salaried, so you're exempt from overtime. That is not how this works. And Curt and I could do our lecture just on this, but there's a two-step test, both federal and at least in New York State, and I'm sure many states, in order to be exempt from overtime. First is you have to meet a salary threshold. You have to get paid at least a certain amount. So here they've now increased it for 24 to $43,888 a year. And then in 25, where they will come in line with New York State, they get to $58,656 a year. You cannot just say, well, fine, you're a professional, or you're a fire chief, the fire chief who does all administrative work. But if you only make $40,000, it doesn't matter, right? Now, this probably isn't going to affect too many departments because most of their white collars, their brass on their white collars, probably get paid more than 43 and then 58,000. But if not, and you want to keep the threshold, you want to meet the threshold for step one, you better bump them up in pay. The second part of the test, which we're not going to cover here, right? Assuming you get past the salary threshold as step one, the second part is what are your job duties? And we just talked about a similar issue, right? Or you better have a policy that talks about what your job duties are. And if you do not, well, then you risk that your employee, who probably is complaining when you fired them, your employee is going to come back and say, well, now I'm due 3 years, 6 years, whatever of overtime because you violated the FLSA or you improperly didn't pay me for my time. You categorize me as exempt and salaried, but I should have been hourly. And now you owe me a ton of overtime, maybe times 2, right, as damages. So please, everybody, if you are unsure about whether your employees are exempt from overtime or not, two-part test. Salary is the first one. Please make sure to look at the new threshold limits, which is federal. And 2, then you got to look at the job description and what they do, and it better be in writing because that's Exhibit A. Well, on behalf of Curt and I, that's it. That's all we got for this week. Curt and I have an exciting announcement coming to you next week. So please watch. It's very exciting on our end. Everyone's going to like it, I hope. But we definitely have a very exciting announcement for next week. So wait till that. And until then, Curt, guessing you're running to a wildland fire because that's what you would run out for. He had a huge one last year. So please, everybody, be safe, and we will see you next